Hey there, I'm estate planning attorney Paul Rabelais, and in this video, I'm going to describe 5 reasons why, if you own a business, you may want to strongly consider getting your estate legal affairs in order. So some small businesses are the backbone of the American economy. Many new businesses are formed every day, and estate planning allows you to control what happens to your business when you die or are no longer able to run it. And whether you are a member of an LLC, a shareholder in a privately held corporation, or even if you just have a sole proprietorship, here are 5 reasons why business owners should take action to protect their business, their family, and their estate. First, you may want to leave your ownership interest in your business to one or more particular individuals. Perhaps one or more of your heirs knows more about your business than the other heirs, or perhaps one or more heirs is employed in your business. And it just makes sense that you leave your ownership interest in your business to certain heirs to the exclusion of others. Now, when you leave your business to only one of your heirs, there's often a decision to make regarding whether they get your business off the top with the rest of your estate to be divided equally among your heirs, or whether the value of the ownership interest in your business that you leave to one heir counts toward their percentage of the overall estate. For example, let's say that you have 2 kids and you want to treat them equally, but only one of the heirs will inherit your business. If your total estate, including your business, is worth $6 million and your business is worth $2 million of that, then in order to be equal, you leave your $2 million business and another $1 million to the heir that will get the business, while the other heir gets the remaining $3 million of your estate. And anytime how much heirs inherit is based on the value of your closely held business, a tricky aspect is figuring out how that privately held business will be valued when you pass away. That executor appointment in your will or successor trustee appointment in your living trust may be a key appointment in that they may control how your business gets valued when you pass away. Second, you may want to leave your business in a trust when you pass away. Some parents say something like, I want my business when I die to benefit all 3 of my children, but I want one of my children to be able to make all the important business decisions. That parent may leave their ownership interest in a trust when they pass away and name one child or one person as the trustee of that trust after the business owner dies, but the 3 children are equal income and principal beneficiaries of the trust. This way, that business-savvy trustee can make all the important business decisions, but all of the children or heirs would share in the business profits or dividends from the business. Third, the value of a business, particularly when a business owner dies, can go down significantly while the business meanders its way through probate. It's often a wise decision for a business owner to create their revocable living trust and transfer their ownership interest in their business to their trust so that when they pass away, that successor trustee that's designated in the revocable living trust instrument can immediately make critical business decisions, whether those decisions include a decision to sell a business or to enter into other important business agreements. If your LLC membership interest or your corporation's shares are in your name when you die, it may take months or longer before a court confirms an executor of your estate or appoints an administrator of your estate to be able to transact your interest in the business. And all the while, the value of your business may go down, down, down. The 4th reason business owners should engage in estate planning is if through your illness or injury or other means you get to a point during your lifetime that you are unable to transact as a business owner, then someone, probably a family member, will be forced to sue you in an expensive and time-consuming guardianship proceeding in order to have a judge declare you incompetent and in order to have a judge appoint someone as your legal guardian. It will likely take months or longer for others to dredge through these legal proceedings, and no one can transact for you until those wheels of justice eventually get to a point where someone can handle your business affairs during your incapacity. Most business owners sign the appropriate durable power of attorney documents where they make it easy for a trusted loved one or business partner to transact for the business owner if the business owner becomes incapacitated. And transferring your business interest to your revocable living trust can also help here because your revocable living trust will likely provide that if you become incapacitated, then your successor trustee can immediately step in and transact your business on your behalf. And the fifth reason business owners should engage in estate planning is taxes. It can be tough when a business owner dies and the value of their business is included in their estate, and a 40% estate tax, that is due in cash, must be paid within 9 months of the business owner's death. There are a number of things business owners can do during their lifetime to minimize the impact of the federal estate tax, including getting some of the value out of your estate during your lifetime, taking advantage of certain elections that estates of business owners have in order to defer the payment of the estate tax, and ensuring that if the business owner is married, both spouses utilize their estate tax exclusion amounts to shield the business from estate tax. Now, I could even list more than 5 reasons business owners and entrepreneurs should engage in estate planning, such as conflict avoidance through clarity, peace of mind, avoiding all the default rules that apply when you have no plan in place, protecting the inherited interests of minor kids if the business owner has minor kids, protecting the business interests that your children inherit from their divorces, and incorporating buy-sell provisions when a business is owned by 2 or more business owners. Our national estate planning law firm, America's Estate Planning Lawyers, helps business owners around the country get and keep their estate legal affairs in order. Feel free to click the link in the description below to request a Zoom estate planning design meeting. See you around.